So the restructuring process, you're really confident that you meet all the eligibility, you've got a great plan that you want to propose to the creditors, you've gone through a lot of work here to get yourself all together and make sure your employees are on board, make sure your creditors are on board. But one of the really critical areas is who can actually assist you through that process, who's allowed to be the restructuring practitioner. That is a really critical question and one that we're asked all the time. Now, the way the rules and the laws are going to work is that a restructuring practitioner must be a registered liquidator. Okay, now that might sound a little bit funny with the way the terminology is, but effectively think as someone who would otherwise be the administrator can be this restructuring practitioner. But what the government has also done is they've added a little carve out around who can also be a registered liquidator. And this might sound a little bit complicated, but someone who can be a registered liquidator to do only this restructuring process. Now that carve out is only for accountants, so it's people who are CA or CANS, CPA or IPA qualified. They have memberships with them. They need to go through this committee process to get approved as this restructuring practitioner. Now that committee is going to look at things like that person's prior experience doing this type of work, doing liquidations, doing receiverships, all that type of stuff. So whether it really broadens the scope of who will be allowed to do this, to be honest, I do doubt it. And the main reason for that is the committee. So the committee is what will be quite a complicated process. I would imagine there's going to be a lot of applicants trying to apply for it. I would say there's going to be long delays on who's going to be allowed to do it. So accountants who are interested in it need to look at the education and experience requirements. I think if you've never worked in insolvency before, I personally don't think that you would meet that, but that doesn't mean that a committee may have a different opinion. And what we've identified, particularly from some of the governing bodies who do this type of work, who they very much have the view that only people who have sat various education courses dedicated purely to insolvency, and that should be allowed to do this type of work. So we'll see what happens. What it means for directors and creditors is that when you approach someone to do this type of work, you need to make sure that you can run a search on ASIC that says this person is a registered liquidator. Okay, that's the number one most important thing. If someone comes to you and says that they can do all this work for you they'll help you through the process and they are not registered as a liquidator, they are not authorized to do that work. That's heads down, not allowed. First and foremost, only registered liquidators are allowed to do this type of work. And I would imagine that at least for the first 6 months, the overwhelming number of people who will be allowed to do it were already registered liquidators before December. You might find that over the next 6-12 months, that will broaden slightly to include some accountants. When you're thinking about doing this process, come and talk to SV Partners. We're certainly able to point you in the right direction of what you should be doing, what you can do, and help you formulate your plan, and hopefully get a really good return for your creditors and keep your business going. And at the end of the day, one of the really good parts about this restructuring process is that you as the director are protected in essence from your director guarantees, and that extends also to the plan. So really important that you come and talk to someone like SV Partners to truly appreciate and understand how all that will work, to not only protect yourselves, your business, your creditors, but to get the most for everyone. So thank you very much for listening.